Good morning to everyone who's joined already. We'll get started in a few minutes, hopefully right at 9 o'clock. And well, thank you for joining me today to learn about the open meetings law or learn a little bit more, get updated on the open meetings law. Before I get started, I just want to do a sound check because last time I was technically inept. So if someone wouldn't mind sending me a quick note in chat if they can hear me. Lovely, thank you. I got a couple of yeses, so we're good to go. Good morning, everyone. This is Kristen O'Neill, Deputy Director and Counsel for the New York State Committee on Open Government. So this morning we're going to be doing a virtual program on the New York State Open Meetings Law. For some of you, it may be a lot of new information. For some of you, it might be just a small refresher. But either way, hopefully it will be beneficial. This program is being recorded and will be posted on the Committee on Open Government's website. We have a section of our website that is titled, I would like to view training materials and recordings. As soon as I'm done today and as soon as I get the recording back from WebEx, I'm going to ask our IT folks to upload both the recording and the most up-to-date version of my both Freedom of Information Law and Open Meetings Law PowerPoints to that website. So if any of you are aware of colleagues or friends that had wanted to view this program but didn't have an option, didn't have the ability to do so, it will be recorded and available for later viewing. What I will do is, if you have questions, and feel free to add them into chat as we go along, but I will wait until the end to do a Q&A. But if there's something that I'm talking about that you just you need some clarification on, it's completely fine if you'd like to type it into chat as we go along. It's just that I won't actually answer it until we get to the end. Up on the screen is my contact information. Anyone is welcome to contact our office. You don't need to necessarily speak with me. We've got other attorneys in the office that can be of assistance to you. Our executive director's name is Shoshana Boulay. We have two senior attorneys. One is Kristen Smith and the other is Miguel Carlo Batista. And both of them, or any of us, can provide you with legal guidance or just practical guidance regarding either the Freedom of Information Law, Open Meetings Law, or the Personal Privacy Protection Law. There's a lot of great helpful information on our website, the opengovernment.ny.gov website, or you can call us at 518-474-2518 or email us at coog@dos.ny.gov. So the New York State Open Meetings Law is codified in Public Officers Law and was passed in 1976. The declared legislative intent stated that it is essential that public business be performed in an open and public manner, and that citizens be fully aware of and be able to observe the performance of public officials. Citizens have the right to attend and listen to the deliberations and decisions that go into the making of public policy. So there are a couple aspects of this that I want to focus on or bring attention to, is that the public's right to attend and listen and observe a meeting that is subject to the open meetings law is not just about watching these individuals vote or make the final decisions. It should also be about watching them have the conversations and discussions that lead to those decisions. So not just the final say, the yays or the nays, but all the interesting conversations back and forth that go into those final votes. Who is subject to the open meetings law? The open meetings law governs the conduct of meetings of a public body. That's the term used by the statute, a public body. And the term is defined in the open meetings law as any entity for which a quorum is required, and I can talk a little bit more about quorum in a few minutes. It has to consist of 2 or more members performing a governmental function. It either could be a governmental function for the state of New York, or it could be a municipality such as counties, cities, towns, villages. It's also entities such as school districts. So your local boards of education are subject to the open meetings law, library boards of trustees. And then there are thousands of units of local government across the state of New York, and many of them have some type of governing body. Or in addition to those governing bodies, there are also entities that are created by statute to perform a specific statutory function. And many of those also are considered public bodies that are required to comply with the open meetings law. If you have a public body, for example, the larger public bodies like a county legislature, and it's that has, let's say, for example, 17 members, some of those larger bodies like to break down some of their assignments into committee work, makes, lessen the load for all of the entire body, and assign different committees to different tasks to hopefully lessen the workload. And those committees are also subject to the open meetings law. So again, say you have that 17-member county legislature, you might have a committee that is made up of 3 individuals or 5 individuals, and all of those individuals, or most of those individuals, are county legislators. When that's the case, those committees are public bodies that where they have to have their meetings in compliance with the open meetings law. There are other entities that gather together to provide some type of assistance support to a government entity, but don't necessarily rise to the level of being a public body. Those entities are generally considered advisory bodies. So for example, if you have an entity that is voluntarily created by either by the state or by a municipality, there's no statutory mandate for these entities. They are voluntarily created. They don't serve a statutory function, and their entire purpose really is to brainstorm ideas and come up with ideas and recommendations and advice for the larger governing body. So these advisory bodies that really their only function, and I don't mean to minimize that because it's a great function, but their primary function is to provide advice to the municipality or to the larger public body. Under those instances, in general, those entities are not going to be considered public bodies that need to hold their meetings in compliance with the open meetings law. I spend a little bit of time talking about video conferencing because it still continues to be a bit of an issue. Someone asked me not too long ago, oh, haven't we all figured this out by now? And unfortunately, the answer to that is no. There still seems to be a little bit of a complication about understanding when video conferencing can be used and how video conferencing can be used to hold a meeting of a public body. So I'll try to go over that and spend a little bit of time here. I break it down. My rule of thumb is the pre-COVID way and the post-COVID way of using video conferencing. So the pre-COVID way has been in effect since August of 2000. So we've got 25 years of video conferencing where public bodies have been allowed to use video conferencing in some way. And the pre-COVID way meant that all members of a public body had to be present at a public location. They had to be present at a location that was open to the public. And the location needed to be included in the meeting notice. So the meeting notice might say, for example, using my own Committee on Open Government as an example, that members of the committee will be meeting in Buffalo and in Albany and in New York City at Department of State offices. So some of our committee members will be present at each of these locations, and the public is welcome to attend in person at any of these locations. And we're going to connect all three of those locations together through the use of video conferencing. So we've got big screens set up, and everybody in Albany can see everybody in New York City and Buffalo and vice versa. We can see and hear each other, and the public can see and hear people that are present at all of those locations. So that's what I consider the pre-COVID way of using video conferencing to conduct meetings. The newer way, in 2022, Governor Hochul signed into law an amendment to the open meetings law that expanded in a somewhat limited way the permitted use of video conferencing to conduct meetings. And this is where a member of a public body may participate via video conferencing from a private, unnoticed location, but only if certain criteria are met. So there's some hoops that need to be jumped through. And if the member of the public body is experiencing an extraordinary circumstance. What is an extraordinary circumstance? The open meetings law defines the term to include disability, illness, caregiving responsibility, or any other significant or unexpected factor or event which precludes the member's physical attendance at such meeting. So here you can see the legislature is showing an intent for a preference for in-person meetings by referring to it as extraordinary circumstances, by talking about significant or unexpected factors. By using that type of language, the legislature is showing a preference that members of the public body appear in person, and that only under very limited circumstances are they permitted to attend from a private location that is not open to the public. In order to take advantage of this provision, governing bodies, so for example, the state legislature, county legislators, county boards of supervisors, city councils, town boards, village boards, they would have needed to have passed, adopted a local law. All other public bodies had to adopt a resolution following a public hearing if they wanted to take advantage of this extraordinary circumstances video conferencing provision. In addition, every public body had to establish written procedures, and those procedures had to be conspicuously posted on the public body's website. I don't think I mentioned this earlier, but at this point, the original law that was passed in 2022, it was originally set to expire in July of 2024. during that year's budget process. It was extended, and the expiration date is now July of 2026. So we will have to anxiously await to see what happens this coming next summer, to see whether it gets extended again. Perhaps it will be made permanent. My hope is that it is not removed or repealed entirely, because I do think it adds benefit. But we will just have to wait and see what the actions the legislature take this coming, whether it's during the budget season or closer to the time where the statute is set to be repealed. Chapter 56, this extraordinary circumstances video conferencing provision, requires that a minimum number of members have to be present to fulfill the public body's quorum requirement at physical locations that are open to the public. This can be more than one physical location, like, for example, that I use with the Committee on Open Government, where you've got open locations in Buffalo, Albany, and New York City. We could have 3, 3, and 3, and still there we would have a quorum of 9 of our 11 members. There are 3 of them in Buffalo, 3 of them in Albany, 3 of them in New York City. That's fine. But if we only had, for example, 5 members at total at all 3 of those locations, that would not be sufficient. That would not meet the quorum requirement, because you have, in order to have a quorum, you have to have a majority of the total membership. So with our Committee on Open Government, with 11 members, regardless of how many people are actually currently serving on the committee, the number that you look to determine what a quorum is the total number you're supposed to have. So a quorum of the Committee on Open Government is always 6 members. So we need to have a minimum of 6 members present at public locations. So the people that participate from a physical location that have been properly noticed and open to in-person public attendance count towards the quorum. And in addition, the law was amended in the spring of 2023 to say that if the member's extraordinary circumstances is a disability as defined by New York State executive law, then that person can also count towards the quorum. So the person has a disability as defined by New York State executive law, and they are video conferencing from a private remote location. They are permitted to count towards a quorum. Who does not count towards a quorum? Any other member of the public body who participates from a remote location that is not open to in-person public attendance. They do not count towards a quorum. But once you have a quorum, once your public body has a quorum, who can participate and who can vote? Members who are participating from the physical locations that have been properly noticed and open to in-person and public attendance are permitted to attend in person. And members who video conference from a remote location due to extraordinary circumstance can participate and vote as long as a quorum has otherwise been satisfied. Notice. Notice of every meeting of a public body must include the date, time, and location, and, if appropriate, instructions for virtual attendance. The notice must be given prior to every meeting to the media. This does not mean that the public body or the agency that houses the public body has to purchase a legal notice. It just means that the media must be notified that the meeting is going to take place. The notice must be placed in a designated physical location. And if the agency or public body has an active website, the notice must be posted on that website. In terms of timing, regularly scheduled meetings that have been scheduled at least 1 week in advance, 72 hours notice prior must be given. The notice must be given at least 72 hours prior to the meeting. If for some reason a public body determines that it must have a meeting and it doesn't have the ability to provide 72 hours notice, if there's some sort of emergency need to have a meeting on short notice, public bodies are permitted to do that. They must give notice to the extent practicable at a reasonable time prior to the meeting. The Open Meetings Law does not, in the language of the statute, doesn't specify when a public body is permitted to have meetings on short notice, but the courts have weighed in and the courts have stated that the propriety of scheduling a meeting less than a week in advance and providing less than 72 hours notice is dependent upon the actual need to do so. If extraordinary circumstances video conferencing is used, the notice must include information stating that video conferencing will be used, must state where the public can view and or participate in the meeting remotely and in person, and the notice also must include information about where documents and records that are scheduled to be discussed will be posted or available. Speaking of that obligation, there is a provision of the Open Meetings Law that requires that all records scheduled to be discussed by a public body during the open portion of a meeting must be made available upon request and posted online at least 24 hours before the meeting if the agency maintains a regularly and routinely updated website and utilizes a high-speed internet connection. It used to be prior to the fall of 2021 that the records just had to be available prior to or at the meeting, but when the law was amended in the fall of 21, it placed a 24-hour minimum time frame for making those records available. What types of records are we talking about? Any proposed resolutions, laws, rules, regulations, policies, or any amendments to any of those types of items? Or any records or portions of records that would be public under the Freedom of Information Law that are scheduled to be discussed during the open portion of the meeting. This does not apply to records that are discussed in executive session. Minutes. Minutes of a meeting must include a record or summary of all motions, proposals, resolutions, or any other matter formally voted upon and the votes thereon. There's also a provision of the Freedom of Information Law that requires every agency to maintain a record of how each individual member of the public body voted. So while that's not an obligation under the Open Meetings Law, it is an obligation under the Freedom of Information Law. So please keep that in mind if you are responsible for preparing minutes. While the Open Meetings Law says, for example, you could have a town board that has 5 members and the minutes could say the resolution passed 3-2. But under the Freedom of Information Law, you do have to have a record of how each member voted. If extraordinary circumstances video conferencing is used, it must include which, if any, members participated remotely. Minutes of an executive session only need to be prepared if the public body votes in executive session. So for example, if a public body deliberates on a particular permissive topic in executive session, but doesn't vote at all, or waits until it's an open session to vote, then no separate minutes of the executive session would need to be taken. But if there is a vote in executive session, minutes, separate minutes, or at least minutes that must be prepared more quickly, have to be prepared of that executive session. In terms of timing, it is 2 weeks for an open session and 1 week for an executive session. So those minutes must be prepared and made available upon request. It doesn't matter whether those minutes are unapproved or still in draft form. In the fall of 2021, the law was amended to require that those minutes be posted on their website within 2 weeks of the date of an open meeting or 1 week of an executive session. A public body can choose that in lieu of posting their minutes, they could post an unabridged video or audio recording or an unabridged written transcript of the meeting, but this does not relieve the public body of its obligation to prepare the minutes and to make those minutes available upon request. Recording. Any meeting of a public body that is open to the public shall be open to being photographed, broadcast, webcast, and or otherwise recorded or transmitted by audio or video means. Person who shows up at an open meeting is permitted to record, does not need to notify the public body, does not need to get permission from the public body. It has that statutory right to record. An agency is permitted to establish reasonable rules to limit disruption and interference. We have the Committee on Open Government has model rules available on our website. So if a public body is looking to see what might be determined to be reasonable in terms of reasonable rules, we do have those model rules available on our website. But again, the intent is to limit disruption and interference, not to actually interfere with the person's statutory right to record or take photographs. An agency or public body is not obligated itself to record its meetings unless one of its members is participating remotely due to an extraordinary circumstance. If that's the case, the agency is obligated to record. It is obligated to post that recording on its website and to keep that recording for up to 5 years on its website. So now we're going to talk about one of the two members that, the two avenues that allow a public body to meet behind closed doors. So the first one we're going to talk about is the most commonly known avenue for meeting behind closed door, and that's an executive session. An executive session is defined in the open meetings law as a portion of an open meeting that is not open to the public. An executive session can never be prior to the start of an open meeting, nor can it be 100% separate from an open meeting. It could be an executive session could end up taking a large percentage of an open meeting, but it does not, it cannot be the entirety of the open meeting. In order to enter into executive session, a public body has to make a motion during open session, during a properly noticed open meeting. Then the public body is permitted to make a motion to enter into executive session, and the motion must be specific enough to reflect to fellow board members and to the public that the body is entering into executive session for a proper purpose. The courts have spent a lot of time on this issue. They've provided quite a bit of guidance about what is a sufficient motion to enter into executive session. What's important is A, that it's enough information to show that it's a proper purpose, and B, that it's not merely parroting the language of the statute. That's what a court is going to look at. Up on the screen right now, you'll see the permissive reasons for entering into executive session. I would say only a handful come up on a regular basis. So I'll talk about some of those. So let's say letter D. Letter D permits a public body to discuss, have discussions regarding proposed, pending, or current litigation. When making a motion to enter into executive session, the courts want the public body to identify which litigation is being discussed. Because this, as a reminder, this is an opportunity for the public body to discuss litigation strategy. Also, as a reminder, it is not intended as a way for a public body to discuss sensitive matters that may potentially down the road lead to litigation. There's many topics that public bodies, governing bodies such as town boards and village boards might consider sensitive, and they are worried perhaps that they're going to get sued if they make a decision that the public doesn't like. But the fact that the subject matter is sensitive is not enough to trigger this ground for entering into executive session. There has to be either active litigation, there has to be some sort of clear intent to enter into litigation, for example, a notice of claim, or the public body itself is making a decision as to whether initiate litigation. That's the type of topic that is permitted to be discussed, and the courts want that public body to identify specific litigation. Another common ground for entering into executive session that many public bodies inappropriately refer to as the personnel ground. The courts have repeatedly said that making a motion to enter into executive session to discuss personnel matters is not sufficient to comply with law. The word personnel does not appear in the statute. So instead, you look to what the language of the statute actually says. And if you read through it, it's a jumble of words. It's a lot of language, which is again why the courts don't necessarily want you to parrot the language of the statute. They want you to pluck the appropriate language from the statute that applies to your specific situation. So the statutory language is discussions of the medical, financial, credit, or employment history of a particular person or corporation, or matters leading to the appointment, employment, promotion, demotion, discipline, suspension, dismissal, or removal of a particular person or corporation. The courts don't want to hear that. What they want to hear, for example, might be, we are entering into executive session to review and discuss employment applications that we received relating to this specific job opening. Or we move to enter into executive session to discuss a disciplinary matter relating to a particular employee. The courts would not require you to identify the applicant or identify the employee that is subject to the disciplinary investigation. They just want you to be specific enough so that the public knows that it's a proper topic. The last one that comes up, probably not as frequently as the other two that I mentioned, but is the proposed acquisition, sale, or lease of real property. So for example, if a public body is considering purchasing a piece of property or considering selling a piece of property, they can have conversations relating to the purchase or sale or lease in executive session if having a conversation in public regarding those topics would substantially affect the value of the property or of the exchange of security. Sorry, I just accidentally muted myself. That's what I did. Anyway, so now I'm going to go back a screen. Come on. There we go. The second avenue for meeting behind closed doors is the less commonly known of the two, and sometimes these two types of behind closed doors meetings get confused or conflated. So we'll remind everybody that they are two separate sections of the statute, and they're two separate ways of approaching them or entering or having these types of meetings. Whereas an executive session is always a portion of an open meeting, if one of these exemptions set forth in section 108 of the open meetings law apply, the open meetings law does not apply at all. It's as if the open meetings law does not exist. There's no obligation to have a meeting first to have a conversation that is covered by one of these three exemptions. There's no obligation to make a motion to go into an exempt session. It's just completely separate from the requirements of the open meetings law. The first exemption is for judicial or quasi-judicial proceedings, except for proceedings of the Public Service Commission and zoning boards of appeals. The second exemption is for deliberations of political committees, conferences, and caucuses. So for example, if you have a town board that is made up where 3 of its members are one political party and 2 of its members are adherents to another political party, the 3 members, let's just randomly, let's say the 3 members are Democrats. Those 3 Democrats could, even though they represent a quorum of the town board, could meet and discuss whatever they want, whenever they want, without noticing to the public and without opening those conversations to the public. They can't vote at one of these exempt sessions, but they can have those conversations. The third exemption is probably the most common, and it gives the public body the opportunity to have discussions relating to matters made confidential by federal or state law. The most common state law that is triggered by this exemption is New York State Civil Practice Law and Rules that codifies the attorney-client privilege. So if a public body wants to have a conversation with its legal counsel, its town attorney, its city attorney, its county attorney, or if at the state level you have someone from counsel's office that represents that public body, they are permitted to have a conversation with their attorney where the attorney is playing an active role by providing legal advice to the public body, and that conversation is covered by the attorney-client privilege. If that's the case, that conversation is exempt entirely from the open meetings law. This can occur during an open meeting, and there's no obligation to make a motion to enter into executive session because it's not executive session. What I was, as a courtesy, I think the best way of going about it is for a public body just to notify the public that they need to have a brief closed door discussion for the purpose of receiving legal advice. And that conversation is exempt from the requirements of the open meetings law. So notifying the public so they don't think the public body is just being rude by walking out, for example, but there's no obligation to make a motion and to vote on the motion. So the Committee on Open Government is an advisory entity. Our staff of attorneys has the authority to provide both practical and legal advice relating to the Freedom of Information Law, open meetings law, and personal privacy protection law, but we do not have enforcement authority. We cannot compel an agency or a public body to take certain actions. We do not issue counseling memos to agencies or public bodies, basically giving them slaps on the wrist when we think they're misbehaving. That is not our role. Our role is to provide advice to anyone that asks for it. Enforcement of the statute is through the initiation of a Civil Practice Law and Rules Article 78 proceeding. If a petitioner substantially prevails, the court has the authority to award costs and attorney's fees. If the court finds that the violation of the open meetings law is significant enough, they could potentially invalidate actions taken at that meeting or taken as a result of meetings that were held not in compliance with the open meetings law. If the court finds that the public body engaged in mere technical violations, they would not invalidate the actions taken at that meeting. Another statutory penalty that can be imposed is taking open meetings law training from our office, but hopefully that's not too painful. So I'm just gonna close out of my PowerPoint and I'm gonna open up my chat window so that I can see if people have questions as we went along. I'm gonna open this up so I can see it nice and big up on the screen. Move it over. If I think a question is maybe a little bit too specific to be of general interest to everyone in attendance, I'll probably ask somebody, that person to reach out, but I'll start going through. The first has to do with, the first is again, one of those, I think, questions that's really, I think warrants a direct contact with our office. It has to do with, the question says, it relates to the co-application of the Freedom of Information Law, records made confidential by state or federal statute, or records exempt from FOIL by state or federal statute, and the Open Meetings Law exemption. And then it goes on to say, particularly that's granted by the CPLR. When, if at all, does the Open Meetings Law minuting trigger in the case of the invocation of Criminal Procedure Law and Rules, Section 4503? I don't know that I understand the question, because as we just discussed, when a public body is having a conversation that is confidential by statute, specifically the attorney-client privilege, the open meetings law doesn't apply at all. So there is no obligation to have a open meeting when a public body wishes to have a conversation with their attorney, and there would be no obligation to prepare minutes of that conversation. If that's the question, that's great. Hopefully I just answered it. If not, that person can contact me directly. Next person says, are the only persons allowed to vote when attending remotely those with the extraordinary circumstance? Okay, so again, I'm not quite sure that I understand the question. So let's say you have a 5-member town board. If you have 3 members of your town board that are present in person, then you have a quorum. You've met your quorum requirement. Let's say a 4th member is attending remotely due to an extraordinary circumstance. That person also is permitted to participate and vote during the meeting because the quorum was met by the 3 people that were attending in person. If you only had 2 members present in person at an open location, such as the town hall, if you wanted a quorum, the only person that would attending remotely that would allow you to get to a quorum is if you had one of those individuals experiencing an extraordinary circumstance that has a disability as defined by New York state law. That person who has a disability would count towards a quorum. But once you have a quorum, all of the members that are appropriately attending, either in person or remotely, can participate and vote in the meeting. Next question has to do with New York State town law. So I'm going to skip over that because that is not our area of expertise. I'm not going to, I can't provide advice regarding New York State town law. Someone asked me to compare and contrast New York State federal statute. I declined to do so. Next question is that the agency must not regurgitate the statutory language, but must state with specificity and particularity the reason for entering into executive session. Does the same requirement? Again, I need to remind the person that's asking that if you listened all the way through the program, you heard me state that the open meetings law is exempt from the requirements of the open meetings law. There is no obligation to make a motion to enter into executive session. Next question is, it appears that both FOIL and the open meetings law provide for Article 78 appeal of administrative determination. It's very common that local governments violate or abuse FOIL and the open meetings law provision, but the 2 statutes are relatively toothless and the onus of enforcement falls on the shoulders of the public. With the COOG encourage legislation to more stringently enforce the provisions of the open meetings law. I encourage you to look at the annual report that is put out every year by the Committee on Open Government to the governor and the legislature. That is where a response to that inquiry would be located. Next person says, can you please clarify what needs to be posted on the web for meetings? Is it all meetings like planning and zoning, or just meetings of the Board of Trustees? And does the whole packet have to be posted, or just items discussed that require a vote? All right, so the open meetings law applies to all public bodies equally. There is no distinction between, for example, the Committee on Open Government, between the state legislature, between a town board or a city council. The open meetings law doesn't care what kind of public body you are. It applies to all public bodies equally. What is required to be posted is 1, notice of the meeting, and 2, records scheduled to be discussed at the open meeting. Whether those are items that are on the agenda, or if you don't have an agenda, it could just be items that your board knows they plan to discuss. It's not really relevant whether there's a planned vote. It's the triggering language is that the records are scheduled to be discussed during the open meeting. The goal is for the public to be able to follow along with the public body's conversation relating to those records. The next question is, can public bodies vote by a show of hands so long as they keep a tally of the record? The open meetings law doesn't really establish the procedure for voting as long as the person taking the minutes knows how each individual member votes. So for example, the open meetings law doesn't specify that people have to say yay or nay. It's just, they talk about the minutes. The minutes have to reflect that that the resolution was passed, what the vote was, whether it was 3-2, and then the Freedom of Information law requires that a record be created that reflect how each individual members voted. Someone asked, will the attendees receive the slides by email? No, I will not be sending them out by email. They are going to be posted on our website, as I noted at the beginning. Where those are going to be, they will be on the Committee on Open Government's website in the section relating, I would like to view training materials and recordings. Someone asked this question. I think I already answered this question. Suppose others are attending remotely who do not have a disability. Do they vote? If a quorum has already been met and the person who's experiencing a disability, experiencing an extraordinary circumstance is attending remotely, they can participate and vote as long as the quorum has already been met. Let's see. I think I am through with the questions that are relevant for this proceeding. If you have a question that I skipped over, it's because I just don't think I think you either I've already addressed it or it's not appropriate for this setting. So if you do have a follow-up question that specifically relates to the open meetings law or the Freedom of Information law, you're welcome to follow up with us via email. But the ones that I have left don't meet that criteria. Again, as a reminder, I will get this recording posted up on our website, and the slides I'm going to put in a request as soon as we're done here to have both my last week Freedom of Information law slides and the open meetings law slides posted. The ones that are currently on the website are substantially similar to what we've got here, but these are just some slight updates. So thank you very much for joining me today, and you all have a wonderful day.